Hey, everybody. It's Wednesday night. Welcome to True Crime Wednesday. I'm your host, Lori Hellis, retired criminal attorney and author. Welcome. I'm glad to see folks are starting to filter in. It's nice to see you all, and it's great to be here. I don't know how it is where you are, but in Central Oregon, October is, at least the beginning of October, is usually absolutely a beautiful month, and it has been just heartbreakingly beautiful weather. The trees are all starting to change, so beautiful red and yellow trees among all of the evergreens, and some really nice sunny days, but cool, crisp nights. My daughter is up in Vancouver, Canada, for work and said it's beautiful up there as well. The fall colors are lovely. So I hope wherever you are, it's the same. Um, you know, there is just not a huge amount of stuff out there right now. I don't know why. We're just in this big lull right now. A lot of the cases that we've been following have been sort of set out into next year. And the two big ones, Stefan Stearns and Koberger, they took pleas. So it's really kind of an interesting phenomenon. We don't see this very often, that you just have such a dearth of stuff going on. There are a few things going on that I did want to talk about before we launch into. A lot of you said that you're really enjoying when I sort of do a deep dive into a subject, or last week we talked about the Crumbly appeal, and before that we talked about defamation. So a lot of folks say they enjoy it when I do those sorts of things. So I thought that I would start out tonight sort of in kind of in the order that a case starts. How does a case start? How does it proceed? And so I thought tonight I would just start by talking about probable cause and warrants. Um, and so we'll do that after we wrap up with the few things that are happening in the true crime community. One of the things that is happening is Corey Richins. And there have been a few things happening with her. Probably the biggest thing is the fact that the man who was, that the state claimed she procured the fentanyl from, has now recanted his testimony about that. So if you remember, Corey Richins went to her housekeeper and said, I want to get drugs. She made the excuse that she was trying to get them for a friend who had a back injury. And then she said, I want fentanyl. She actually said, how can I get the Michael Jackson drug, which is propofol? That's administered intravenously, and it's not something that you're going to easily get a hold of on the street. But she specifically did say that she wanted fentanyl. So the word was that the housekeeper went to this guy. She had a guy, and connected her. She went to the guy, bought the fentanyl, and then resold it basically to Corey Richins. So now the guy says that at the time that he was first interviewed and first told the police his story, he was in the middle of detoxing, and it was not a time when his mind was very clear. And so he now says he never sold fentanyl, period, that he only sold OxyContin, and that's what he would have sold to Corey Richins' housekeeper. So what does that mean for her case? Well, there's a lot more to her case than just that, but clearly, it does erase a specific link from her, if he is to be believed, takes a specific link to the fentanyl out of the equation. Now, fentanyl is readily available on the streets, so I don't know that it's yes, you do take out, okay, Corey wanted fentanyl, but we still have the housekeeper who's saying, Corey asked me to get fentanyl. I went to this guy and I got pills. Whether they were actually fentanyl or whether they were OxyContin, I don't know. And does that change the story or change the likelihood of Eric Richins dying of fentanyl overdose? She got fentanyl somewhere, we know clearly because he died of a fentanyl overdose. So it does appear that they're going to have to sort of recoup. The larger question, and I think the question that is going to give everybody some fits and may very well result in it, it in some questions about the charges. The larger question is, why didn't the prosecution provide that evidence to the defense? Remember, the prosecution has an obligation to give to the defense any exculpatory information, information that tends to prove that the defendant is not the culprit, information that could be used to impeach a state witness that that would indicate her lack of culpability. So they did this interview with this guy. It was the second interview with him, but law enforcement re-interviewed him last April. And it was only just as he was being deposed by the defense that they discovered that he had actually recanted his earlier statement. So they didn't find out from the prosecution. They found out in a roundabout way. That's a problem because the prosecution is obligated to share that information, and they had it for a very long time and sat on it. So that's a problem. It's very likely that we're going to see the defense file a motion to dismiss based on the discovery violation. And, but I don't know that it's going to be sufficient for the judge to say, yes, it's enough to dismiss the case the way we saw in um, Alex Alex Baldwin. So we'll wait to see what's going to happen with that. However, it is a big deal. It is a big deal that the prosecution didn't, regardless of whether they have enough information to go forward with a prosecution without this guy. It is a big deal that they didn't turn that information over because they're legally required to do so. So that definitely was a violation both of the rules and of their ethical obligations. And that certainly is going to get some backlash from the defense. Interestingly enough, the same attorney who is representing Corey Richins is also representing Tyler Robinson, and he is the gunman who was accused of killing Charlie Kirk. My understanding is that she is a court-appointed attorney. If you recall, Corey Richins had private counsel, and when they decided that they had to withdraw because of a conflict, then she asked for court-appointed counsel. So we had a bit of a bump in the road in the Brian Walsh case. Now, Brian Walsh is one of several cases in Massachusetts where defendants are attempting to get Michael Proctor's the text messages from Michael Proctor's phone that were brought up in Karen Reed's case as a way, as impeachment information. I got to get my bangs cut here. As impeachment information. And so um, that is still sort of working its way through the judge, trying to figure out how to get this information, because it was the subject of a federal investigation, and it was there was a federal gag order, and there was a federal order that said that once the Karen Reed trial was over, they had a certain number of days, like 30 days, to return all of that information to the feds. And so the prosecution has been trying to file motions with the feds to try and they got them to extend that deadline, but they haven't gotten permission from the feds to release those text messages. And to be honest, I'm pretty sure the prosecution isn't trying real hard to get them, because they're going to be used to impeach Michael Proctor's investigation on all these other cases. So, but in the meantime, Brian Walsh was in court because his attorneys filed a motion saying that they believed that he was not competent to continue to trial. You may have not have heard, but not too long ago, fairly in a few weeks, within the last 2 or 3 weeks, Brian Walsh was attacked in the jail, and he was stabbed in the head, and he was beaten. And he, according to his attorneys, is suffering from terrible PTSD from the beatdown and has not been able to aid and assist. They are determined that they're asking for a determination that he's not competent to stand trial. Now, we've been through this a gazillion times. There's two different issues. Competency comes up in two different places in a criminal case. You can be competent now, but the argument can be that you were not competent at the time you committed the crime. Or you could be competent at the time of the commission of the crime, but now you've decompensated and you're unable to aid and assist in your own defense. You're unable to sit in court and follow along and track with what your lawyers are doing and give your lawyers feedback while you're in court. So that is the problem the attorneys are alleging for Brian Walsh. Doesn't have anything to do with his mental state at the time the crime was committed. Has to do with the fact that since this attack, he has decompensated and they believe is not competent. Now, they had a hearing, and the psychologist who came in and who did a cursory investigation and conversation with Brian Walsh said he knows who all the people are, who what everybody does in a trial. He understands his role, his lawyer's role, the judge's role, all of those things, which are sort of very basic threshold questions for competency. But he is so traumatized by this attack that he's so withdrawn, and he's not tracking, he's not able to concentrate, he doesn't understand what we're saying. And so that therapist recommended that he have a full psych evaluation. So they have committed him to send him off to the nervous hospital for a complete evaluation. And that very likely, the trial is set, I believe it's in February. Maybe it's January, I can't remember. But it's coming up very soon, and the judge said, you know, it is possible that this could impact the trial. If it is determined that he's unable to aid and assist, then he will have to go to the state hospital for a period of restoration. So we will once again wait to see what happens with that. The last thing, oh no, not quite the last thing, the second to the last thing in is that Donna Adelson's trial, Donna Adelson's sentencing may have been moved up until Monday. So it's really unclear right now. I was watching Joel from STS, and he had now I can't think of his name. He's the Tallahassee lawyer on. And the lawyer said it was really unclear. There had been a case management court appearance scheduled for Tuesday, and suddenly that dropped off the calendar, and Monday came on, and it indicated that Monday was going to be a sentencing. But it's unclear whether the pre-sentence investigation has come back yet or not. Now, as it applies to the murder charge is a fixed life without parole sentence. But the additional, Tim Jansen, thank you, Susie. The additional charges, the other charges that she was found guilty of, all carry sentences of somewhere around 30 years. So from the defense standpoint, they're going to appeal. If the first-degree murder case were to get thrown out, they definitely want to preserve those 30-year sentences, because that could mean that Donna could serve substantially less, and there would actually be an opportunity for her to get released. Now, realistically, she's 76. Is she going to get out? No, she's not. But if the first-degree murder case were thrown out, there would be some opportunity for the potential for release. So every state's different in the way the Departments of Corrections works. Sometimes people who have life without parole are not eligible for a lot of the programs within the jail, because they're considered to be teaching the people skills so that they can get out, and rehabilitation kinds of programs. And if you have a life without parole sentence, you're not getting out. So what's the sense of having you participate in programs to rehabilitate yourself? So those may be some of the issues as the reason why they still would want that pre-sentencing investigation, even if the court is going to impose that that life sentence. So it's not entirely clear. It may become clearer as the week goes on and as we get closer to Monday. There was some discussion about whether or not that was too quickly, and whether the prosecution could get victim impact statements in time for Monday. But if you recall, the Markells, because they live in Toronto, so they were there for the trial. The judge permitted them to give their victim impact statements before they went home, so they did not have to come back for those. Now, are the Markells going to be deeply interested in Donna's sentencing and probably appear by Zoom? Sure, they are, but they don't have to be there to be heard by the judge. So I don't know that it's a huge problem to go forward with sentencing on Monday. And the last thing is, before we dive into the world of probable cause, that was announced today that there was someone arrested for being responsible for starting the Pacific Palisades fire in Los Angeles. Now, that is not the fire that was the biggest fire towards Altadena and that area. The Pacific's Palisades fire was down closer to the coast, and but it decimated the community of Pacific Palisades. Something like 1,200 houses were destroyed, and somewhere in the neighborhood of 12 to 14 people died. So it is a big deal. The guy's name is Jonathan Rinderknecht, and he is accused of having started a fire out on a woodland trail that ultimately led to the the sparking of the fire that burned through Pacific Palisades. So before we switch over to talk about probable cause, I want to please ask you, if you are not subscribed, please subscribe. It does make a difference for us, and we appreciate it. Also, hit the notifications, because we do occasionally do a surprise live when something big happens. And so like, subscribe, do all the YouTube things. And thanks to everybody who has done that. Before we get into the weeds about probable cause, I did want to I wanted to say thanks to Denise Hovland, who sent me hilarious t-shirts. Now, we try not to be political on the channel, but I do have this really, really funny t-shirt she sent me. The rest of it is maybe not suitable for the office, so I won't show the rest of it, but they're very funny. And she sent me a couple of those t-shirts. And I also wanted to shout out Dawn Shackelford. Y'all know I'm going to be off the month of December because I'm having knee replacement surgery. And I announced that, and Dawn put in the comments that she is having knee replacement surgery on the 10th. So on Friday. And so we just want to send lots of good vibes, good juju for Dawn. She is a faithful follower and faithful in the chat, and I just want y'all to send some good thoughts her way while she's having surgery. So I think that does just about everything that was on my list to talk about. Oh, I do have one more thing. My husband is going to have a cochlear implant. You all know he's a retired Air Force aviator and flew fighter airplanes, and they're very loud. And you fly them for 3,000 hours, and your hearing deteriorates. So he has been struggling with hearing loss for years, and now has been approved to have a cochlear implant. We're new to the whole idea of cochlear implants. So if any of you out there have had experience with cochlear implants, drop a note in the comments or drop me an email and let me know what your experience has been, because we're just trying to collect as many people as we can, information from people who have experienced it. We understand that there is a rehabilitation period and a learning curve that goes along with it, that it's not as simple as they turn it on and voila, you can hear. There is a period of rehab that goes on that is required. So but I'm just interested to talk to people who maybe are a couple years out and can tell me how they've been doing. So if you fall into that category, drop me an email. or have a family member, somebody that you know. So, okay, let's talk about probable cause. So, probable cause, the idea of probable cause is rooted in the Fourth Amendment to the Constitution, and it says the right of the people to be secure in their it guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it shall not be violated, and no warrants shall issue but upon probable cause, supported by an oath or an affirmation, and particularly describing the place to be searched and the person or things to be seized. Now we're going to parse that up because there's a lot there. It is a very dense little paragraph. So the Fourth Amendment protects a person's right to be secure in their person, houses, papers, and effects. So the Fourth Amendment at its heart is a right to privacy. And it means that the government cannot simply walk into your house, go through your papers, open up your refrigerator, do any of those things unless there is probable cause and a warrant. So now, are there instances where warrants are not required? There are, and we'll talk about those. But before we get to that, what's probable cause really mean? So just like we've talked about proof beyond a reasonable doubt, and we've talked about how that's sort of a spectrum, and the standards of proof are different for a civil case versus a criminal case. So in a civil case, we say a preponderance of the evidence has to prove the case. And that can be as little as 51%. Um, it just is that it's more likely than not that the plaintiff's complaint is true. So when we're talking about things like auto accidents, slip and fall, tort claims, contract disputes, civil property disputes, those sorts of things, the legal standard, the standard of proof, is a preponderance of the evidence. But because we are dealing in taking away people's life or liberty, we hold the criminal system to the higher standard of proof beyond a reasonable doubt. That's more like 98%. So similarly, we have some of these sort of graduated sort of scales when it comes to when the police can make contact with you, take you into custody, ask you questions, all of those things. And once again, they're on a continuum. So the first thing that we talk about is something called mere conversation. So that's if a police officer walks up to you on the street and says, "Hey, how you doing?" "Oh, fine." Having a good night?" "Yeah." "Uh-huh." Everything okay here?" "Yeah, officer, everything's good." This happens sort of, it's 2 o'clock in the morning, folks are leaving the bar, maybe there's a little, the cops trying to make sure everybody's going to be getting safely home, that nobody's getting in their car to drive, but they're just really kind of standing on the street corner observing what's going on. And so there's no suspicion of a crime. No, they don't have to suspect that there's a crime that's occurred. Okay. All right. I got to go get my hair cut on Monday because my bangs are driving me crazy. Um, There's no necessity for a crime to have occurred or for the police to suspect a crime occurred. This is more along their community, I won't say policing, but community involvement. Okay. So if a police officer walks up to you in the street and, I mean, it could be something as simple as there's a parade downtown and the police are kind of wandering around making sure everybody's okay during the parade. And the police walks up to you and says, an officer walks up and says, "Hey, how are you?" "Oh, I'm good." "Good parade, huh? Everything okay here?" "Yeah, everything's great, officer. Thanks." Now, you have the right to remain silent. You don't have to talk to that police officer. Your right to remain silent is absolutely inviolate, and it applies anytime an, a law enforcement officer approaches you, regardless of whether that person is just walking up to shoot the breeze, whether they're walking up to ask if you've been a victim of a crime, regardless of the reason they are walking up to talk to you, you absolutely do not have to talk to the police, and that applies no matter what the motivation is of the police. And you can refuse a search. If a police officer walks up to you and says, "Hey, do you mind if I pat you down for weapons?" "Hell yeah, I mind. You better have probable cause to think I have a weapon in my pocket." So that is mere conversation. Now, looped into that mere conversation is what we call a knock and talk. Same thing. Police knock on your door and they say, "Everything okay here?" "Yeah, why?" "Well, it was a noise complaint from next door, and the neighbors were concerned that um, there was a big loud thump. Maybe somebody had fallen or something. So they called us. We just wanted to check in. No, everything's fine. I was just I just dropped my bowling ball." "Oh, okay, all right. Well, have a good evening. Good talking to you." That's a knock and talk. Same thing. You have no obligation to answer the door. You have no obligation to talk to that police officer, and you absolutely have no obligation to let them in. Now, the cop might say, "Oh, you mind if we come in and take a look?" "Well, yeah, officer, I do mind. I don't see any reason for you to come in my house." "Oh, okay." So that's a knock and talk. That's mere conversation. So the next thing that happens is called investigative detention. This is in for lawyers referred to as a TERRI stop, because the Terry versus Ohio is the Supreme Court case that decided this. And what it says is that there are instances where a police officer can stop you and frisk you without probable cause. But in order to do that, the police officer has to be able to articulate a reasonable suspicion that you may have committed a crime or that you may have evidence of a crime on your person. So, for example, there's a bank robbery and the bank teller tells the police, "Well, the guy was wearing a brown jacket when he held up the bank." And so and he held up the bank with a gun, and we were terrified. And so an hour later, the police are kind of circling the area of the bank, and there's a guy walking up the street, and he's wearing a brown jacket, and he's got his hand in his pocket, and it looks suspiciously like his pocket's bulky, like there might be something more than his hand in there. And so the police pull up and they say, "Excuse me, sir, can we talk to you for a minute?" At this point, mere conversation. Well, the person they stop says, I'm in a hurry. I've got an appointment. I can't stop." And he kind of scurries off down the sidewalk. And when he does, he sort of pulls his folds his arm down across his body, sort of covering up his pocket, and so that's a little suspicious. And so the police decide, well, maybe we better, just out of an abundance of caution, maybe we ought to just check this guy out. So they follow him down the sidewalk, and they stop him, and they say, "Sir, we suspect that you were involved in this bank robbery, and we're going to frisk you for weapons." And that is permissible. Now, what isn't permissible, here's the example. So they search this guy in his brown jacket, and he doesn't have a weapon. Can they then pat down his pants and find drugs in his pants pocket? Absolutely not. That is beyond the scope of their reasonable suspicion. So they pat the guy down. Nope, doesn't have any guns. But, oh, what's this? We have a bindle of meth or cocaine. And so now you're under arrest for drug possession. So the courts have ruled that that is not a permissible, that really amounts to fruit of the poisonous tree, because once you move beyond frisking this guy for a weapon because you suspect he pulled a weapon on the bank teller, once you move beyond that, then you are beyond the scope of the reasonable suspicion, because you didn't have any reasonable suspicion that he would have drugs on his person. You had a reasonable suspicion he might have a gun. So that's a TERRI stop. Now, there are some provisions sometimes where the police don't need a warrant. That would be in an instance where it's really an emergency. So two instances where often police will say whatever was going on rose to the level of exigent circumstances. So one of those is the police come to the door and they are looking for a particular woman they have an arrest warrant for her. And they go to the front door and they say, "Is Mary Smith here?" And the guy at the front door says, "No, there's nobody here by that name." And then down the hall, they see a woman matching Mary Smith's uh, uh, description, running down the hall. And she's going out the back door. And so the police say, "Hey, wait a minute. We're coming in the house to see if we can find Mary Smith, because we just saw a woman who looks like Mary Smith, and we want to talk to that woman who looks like Mary Smith." That is a permissible, if there is an emergency in the house, such as the police are coming because they're accompanying EMTs, and there is a shooting in the home. The police are not going to wait until they get a warrant to go into the house to secure the house, to make sure the gunman isn't still there. So those are exigent circumstances that would warrant the police going in without a warrant. But those are very narrow windows. They're very narrow exceptions to the warrant statute. The other one is automobiles. And the reason is because automobiles are movable, and the police don't necessarily want to leave an automobile that they believe is being used for a crime, because it might disappear while they go get a warrant. So oftentimes what happens is the police will take custody of a car, and then they'll go and get a warrant and to search the interior of the car. So there are limitations to warrantless searches. If the person that they stop a car and the guy in the car has got an outstanding warrant, and they can see drugs on the seat of the car, they're not going to, he's got an outstanding arrest warrant, say, he's a probation violation. So they know this guy probably is needs to be taken into custody. They can see drugs on the passenger seat of the car. They're not going to say, wait right here while I go get a warrant. They're going to take the guy into custody. They're going to report that they've seen in plain sight, which is another exception to the warrant statute. They have seen evidence of a crime in plain sight, and so they're able to seize that because it was in plain view. But those are sort of the narrow exceptions to getting a warrant. Now, we've all followed cases where we're always very interested to see the probable cause affidavit. That is because of the Fourth Amendment, because the Fourth Amendment says that no warrant shall issue but upon probable cause, supported by oath or affirmation, that's a sworn affidavit, and particularly describing the place to be searched and the person or things to be secured. So when we see a probable cause warrant, say for the arrest of somebody like Richard Allen or like Lori Vallow or somebody who's being arrested, the police will sit down and they will outline all of the reasons why they believe that it's more likely than not that Lori Vallow is the person who committed the crime. Okay. Now, remember, this is the same standard that we're going to be using when we determine whether or not somebody is going to be bound over for trial, either in a preliminary hearing or in a grand jury indictment. So we're actually sort of still on the same level of proof. So two things could happen. Warrants are either for arrests or they're for searches and seizures of property. So in the case of an arrest warrant, we're going to get a probable cause affidavit from a police officer who says, I have probable cause to believe that this person committed this crime. And then from there, the reason why warrants are important is because a magistrate, a judge, is going to test the validity of the probable cause before the warrant issues. So there is a gatekeeper who says, do I think, as the objective judicial officer, do I think that there is probable cause that a crime was committed? So we're going to get into the definition of probable cause, but I also want to talk a little bit about, so the average arrest warrant, let's say Lori Vallow's arrest warrant, says, I, police officer, I, Ray Hermosillo, have been investigating this case, and I've found all this information. I've seen satellite pictures that indicate that Chad Daybell's yard was torn up. Now this would be obviously for the search warrant for Chad Daybell's backyard. I have consulted with the FBI's ERT team, and we've looked at these satellite photos where the soil has been disturbed. We have reason to believe, because we have all this phone data, we know the last day that JJ was alive was this day, the last day Tylee was alive was this day. The following day, we got text messages from Chad Daybell to his wife about burying a raccoon in the backyard and burning limbs in the backyard. All things that suspiciously point to perhaps trying to get rid of bodies. And they go through all of that information, and then they take it to the magistrate, and the magistrate says, okay, this is persuasive that there's probable cause, that it's more likely than not that there's evidence of a crime on Chad Daybell's property. These are all the reasons why. And I'll sign the warrant, and then you can execute it. So the following morning, Ray Hermosillo knocks on Chad Daybell's door early in the morning. Mark Daybell comes to the door with a bowl full of cereal, and Ray Hermosillo says, I'm here to serve a search warrant on the property. Now, this was not the first search warrant that had been served on the property, but they go in, Chad Daybell gets up, and from the wings descend the FBI and the evidence recovery team and all of the teams that were out there digging up the backyard. So it all starts with a warrant, and it all starts with probable cause. So it's the same for an arrest warrant. One of the things that was so surprising in the Delphi case was, first of all, that the court sealed the probable cause affidavit for several weeks. When it was unsealed and made public, there was a lot of consternation about whether what was actually was in that that affidavit really rose to the level of probable cause. But probable cause is not a high standard. So the very next step then, if a person is arrested, then the next step is they're charged. Usually they're charged with a document called an information, a DA's information. And that is the first charging document. That's not the last charging document, because in a case where someone is being accused of a felony, the next thing that happens is they want an indictment. And to get an indictment, there has to be probable cause. And you either have to have a preliminary hearing. We saw a preliminary hearing in Chad Daybell's case in Idaho, or it has to be presented to a grand jury. Now, in Lori Vallow's case, they decided to hold off until COVID was the rules from COVID were relaxed enough that they could convene a grand jury. Part of that reasoning is that grand jury proceedings are secret, and we saw that that Chad's preliminary hearing was televised, and so the public got a look at a lot of evidence that perhaps the prosecutor wanted to keep a little closer to their vest as the case was still being investigated. So the probable cause is just a step in that process. So what happens? How do we get probable cause if it's not a police officer who has the information? What if it's an informant? And worse, what if it's a confidential informant? How do we get enough information to a judge while still keeping the informant's identity secret, that the judge will say, okay, I think there's enough here, there's enough probable cause to issue the warrant? That gets trickier. And there is a whole line of cases about informants and how we get warrants with informants. But essentially, it's a two-step process. First of all, you have to convince the magistrate that the facts that you're presenting are believable and constitute probable cause. But then you also have to prove that the informant is reliable. And that's hard to do if you're using jailhouse snitches. So it's less complicated if you actually you have a witness and it's the neighbor next door who heard the big thunk. That's easier. But if it's somebody who is a confidential informant, a jailhouse snitch style, or a drug confidential informant, it gets trickier because you have to be able to tell the judge, "Judge, this person's reliable." Well, how do you do that if this guy's a meth addict who's out selling meth on the streets? It is more, um, it is more challenging. So once the police go to the magistrate and they say, "Your Honor, we have probable cause to believe," um, let's say, for example, in the case of the Daybell trial, we have reason to believe that the evidence of a crime or the instruments of a crime will be found on Chad Daybell's property. Now that's pretty vague. So they usually narrow it down. They're looking for garden tools, they're looking for shovels, picks, burn pit, accelerants, those sorts of things, because what the Fourth Amendment says is that when that oath or affirmation is filed, it has to describe with particularity the place to be searched and the person or things that have to be seized. So it's not enough to just say to the judge, "I think a crime was committed there," and the judge to say, "Okay, well, just go nose around until you find something." That is not sufficient. You absolutely have to be able to go to the judge and say, "Judge, here are all the reasons why I believe the crime was committed there, and here are the things that I think I might find. I might find papers, I might find computers, I might find cell phones, I might find tools, yard tools, shovels, um, uh, all of those things." But the officer has to list those in the warrant and explain to the judge why the officer believes um, that those things will be found on that property. So um, I'm seeing something here uh, that I want to address. So, true crime sushi. I'm going to pop this up. I'm going to come on. There we go. If you have time, I'd love your opinion on not getting a search warrant for Brian Laundrie the night law enforcement went to his parents' house and the RV was in the driveway. It wouldn't have saved Gabby, but, well, that's true. It might have saved Brian Laundrie. He wouldn't have gone out and unalived himself. Um, uh, but apparently, and you have to remember that um, ultimately these are judgment calls by the police. Ultimately, the police at that point didn't believe that they had probable cause to search the RV. They went to the parents' house. They were looking for Brian Laundrie. They were looking for Gabby. Was she there? They had probable cause to go and ask, Is Gabby Petito here?" But did they have, at that point, they had a missing person. They may have had suspicions, but did they really have probable cause to believe a crime had occurred? Now, had they walked by the RV and seen blood on the bumper, that's a different analysis. But to simply know that this woman is missing, that her family is concerned that he may have harmed her, isn't necessarily enough to get a warrant to search someone's home or their vehicle. Um, so I, I I don't know the exact circumstances, but that's my recollection, is that when the police initially went to Brian Laundrie's home and the van was in the driveway, just looking at the van and asking whether Gabby was there or not, they were only dealing with a missing person at that point. So it wouldn't be until later, when things sort of escalated and they began to believe that something nefarious had happened to Gabby, that they would then have to go to a magistrate, get a warrant, say, here's all the reasons why we think that he did something to Gabby. I'm not sure all of those facts really surfaced that early, when they were just looking for her to find out whether or not she was there. So, it's a judgment call by police, but um, police are definitely going to err on the side of not charging into someone's house, because if they find something, they don't want that evidence to be tainted and have to be thrown out. It's better to take the time and get the warrant, know that you did it in the right order, so that when you go into the house, if there is evidence there, it's going to be admissible. You're not going to end up in this fight about, well, was there exigent circumstances? Did they have a reason to go in the house? All of those things. So that's a good question specifically about that case. But my recollection is, at that point, they really were looking for a missing person. So back to the Daybell case. So at the time that they did the warrant to search and seize on Chad Daybell's property, they then started a grid search, did all of the things that you do when you're searching for something. They went through the barn, they took all the tools out, they looked at the pickaxe, they confiscated all of those things, and they realized that the burn pit had been used. They looked through the burn pit, they found Tylee's necklace, they started to find perhaps some some indication of that there was a human there. I think they may have found one or two of her teeth. And so that was the point that they said, okay, now we're we have affirmed our suspicion that there was probable cause here. There's clearly probable cause here at that point. And then they began seizing stuff in order to make the case. Then, of course, they did the grid search and they found each of their bodies. So let's remember that they did not have an arrest warrant for Chad Daybell. They had a search and seizure warrant for his property. So the whole time they're doing this search, they won't let him in the house and they won't let him out there in the backyard because they don't want him messing with anything. And that is permissible. It is permissible to say, you cannot be here while we're doing the search, or you have to sit in this particular spot. You can only be in the house if you're accompanied by an officer. Those are reasonable limitations on someone's liberty. So he voluntarily went out and sat in his car and was making phone calls, the notorious call to Lori in jail. So he was sitting there. He then starts his car, backs out, and goes around the corner. He leaves pretty quickly. The pressure's finally gotten to him. He realizes that they're finding things in the backyard, and he was actually backed into the driveway. So he drives out of his driveway to the road, makes a right, and that property's on a corner. So he makes a right out of the driveway and another immediate right. And about less than a block away, so he was Emma and Joe were living sort of kitty corner from them. So when he went out of the driveway straight in front of the house and made the right turn, he went right in front of Emma and Joe's house. And he got maybe another block up and the police stopped him. And at that point, they had found enough evidence in his backyard to arrest him. So now we've tipped over. We are now no longer, it's not mere conversation. There's not a reasonable suspicion where they can frisk. Now they have probable cause to believe that Chad Daybell committed a murder and buried the bodies in his backyard. So that's the point where they say, you're under arrest, and they hook him up. They don't need a warrant for that. Now, if they were, on the other hand, to say, we're going to go arrest Chad Daybell at his house because we have enough probable cause to believe that he committed a murder. And they go to the magistrate, swear out the arrest warrant, knock on the door and say, Chad, we're here to arrest you. That is a slightly different, a different sequence of events. But in the instance where you clearly have this person who you believe is the perpetrator and the officers are there digging up the bodies, you don't need a warrant to arrest Chad Daybell. What happens then very quickly is a DA's information is filed saying probable cause to believe that he had committed the crime. And then from there, he's held, there's a bail inquiry, and then he's held until either there's a preliminary hearing or a grand jury. So there is not a need for there to be an arrest warrant, although oftentimes police get warrants to arrest people. It's not at all uncommon. Somebody is on probation or parole, more likely, and they violated the terms of their parole. The parole officer swears out an arrest warrant, a probable cause warrant, affidavit, and let me get that right. The parole officer swears out a probable cause arrest affidavit, and the judge signs an arrest warrant for that person. So then the parole officer or another police officer, parole officers are sworn law enforcement agents, go out to this guy's house and they knock on the door and they say, Frank, you violated your parole. We're here to arrest you. That is also a common sequence of events. So I hope that kind of rounds out how a case gets started. Oftentimes by the time we get involved in the case, that stuff's already happened because that's the early stuff. By the time we get involved and we hear about a case, it's usually at the indictment preliminary hearing stage. Either there's been a preliminary hearing and the court found probable cause, or it's been to a grand jury and the grand jury found probable cause. They've issued an indictment, and at that point, then the person is arraigned on the indictment. That's when the judge is going to do an inquiry about bail, whether or not bail is appropriate, and at what level. And that's really where we often come into the case. So we haven't really understood how it all got started. And it all starts with that probable cause determination. And it's a judgment call by police. And yes, there are instances where a defense attorney will challenge whether or not the police had probable cause. And there are instances where a court's going to say, I don't think that there was really probable cause to think this guy committed this crime. There wasn't probable cause to think this guy in the brown jacket walking down the street was your bank robber. Yes, there may have been enough for a TERRI stop and frisk because you stopped the guy, you frisked him for a gun because you thought he'd used a gun in the commission of the robbery. But when you didn't find a gun in his pocket, there's no probable cause. You don't have any identification when it comes to this person other than the fact that they were wearing a brown coat, other than the fact that they were walking on the Delphi Bridge and they had a blue Carhartt jacket on, right? So probable cause is an important protection for us. The Fourth Amendment, I mean, all of the amendments have impacts on our lives and the guarantees of our freedoms. But the Fourth Amendment is one of those really critical stages and those really critical protections for us because it says law enforcement, there's a boundary. The boundary is in a free society, in a society of law-abiding citizens, you may not decide to go into a person's home looking for evidence of a crime unless there's probable cause. So it is a protection for us against law enforcement just for whatever reason going rogue and knocking on our door and saying, we believe that that in your home there's evidence of a crime. And you say, well, what crime? Well, it doesn't really matter what crime. We're just going to come in and look around. And, we might find one if we come in and look around. That is not the way that our criminal justice system works. Now, other countries, maybe. Other countries do not have the same kinds of protections that we do. And it all really sort of funnels down to the rights of the individual to be free from search, seizure of their person, their property, their papers. Because our Constitution really is focused on the rights of the individual, and our Constitution is a limiting document. Our Constitution limits the rights of the government when the government can do X, Y, and Z. Our Constitution is not these are the rights of the government. Our Constitution is these are the rights of the individuals, and the power of the government is limited by those rights. So our Constitution is a limitation on government power, not an enabler of government power. Sometimes we forget that. Sometimes we think, oh, well, the Constitution gives the government the right to, and that's not the way to look at the Constitution at all. The Constitution gives the people the right to be free from government interference in their lives. So ultimately, the Fourth Amendment is a privacy right. And interestingly enough, and I don't want to get into the politics of this, but the legal arguments that underlie Roe versus Wade are privacy right arguments. So they're very firmly rooted in the Fourth Amendment, in the concept that there is not in the Constitution anywhere a right to privacy. But the argument was that if you take the First Amendment right to free speech and to be protected in your from having religious beliefs imposed on you, and you take the Fourth Amendment search and seizure, and you take the Fifth Amendment's right against self-incrimination, and you bring those all together, you can imply from that a right to privacy of the individual. That was the argument that then underpinned Roe versus Wade, and the right to be private in your home and in your own decisions. So Roe versus Wade is built on a long line of cases that started out with cases about who can marry. So the Loving case was in the progeny to Roe. meaning that it was a case about whether or not um, a black and white couple could marry, interracial marriage, and that then the Supreme Court said you have a right to privacy in your home, in your relationships. You have a right to make those decisions for yourself, and the government doesn't have the power to determine who you marry or what race the person is that you marry. That then established that, and then built on top of that were contraceptive cases about the right to contraception for married women, and then the right to contraception for unmarried women, and it sort of stair-stepped up to where we got to Roe versus Wade. But the underlying philosophy, or the underlying legal argument, was that every individual citizen has a right to privacy, and they did that by imputing it from all of the other rights that are given. To say, well, of course we have a right to privacy. Why would we have the right not to incriminate ourselves? Why would we have the right not to have the government search our houses and our papers? Why would we have the right not to um, uh, uh, not to have to go to church, or the right to free speech? All of those things are pinned in our right to privacy. So there's the gee whiz for tonight. So the Fourth Amendment protects all of us, protects us from anybody walking into your home and saying, I'm here to look through your papers, or I'm here to check to see whether or not you have a handgun in your bedside table. Now, there certainly are instances where warrants are not required. For example, if you are on parole, you receive notice that you do not have Fourth Amendment protections if your parole officer decides to come to your house and wants to come in and check whether or not you have a gun in your bedside table. And if you're a convicted felon, you're not supposed to own a gun. So there are exceptions to the idea that you always have to have a warrant, and parolees are one of them. So, well, what questions do you all have for me? While we are listening to those, I'm just going to say hi to a few people. Hello, Don Shackelford. I know that your knee surgery is coming up on Friday. So we're just sending you lots of good wishes and lots of prayer for a really good surgery. And I'm about a couple of months behind you on in early December. So, hi to Crime Sushi. Thank you so much. I've always found it weird because they took the RV later that night, but not laundry. Perhaps it was because it was registered to Gabby. Yeah, that's probably part of it. Um, and the other thing is, really, did they have probable cause to arrest Brian Laundrie? I'd argue they didn't. At that point, they had a missing person, a suggestion by her family that they were worried for her safety, that there had been perhaps some domestic violence between them. But I don't think that was enough for them to say, Brian Laundrie, we're taking you into custody. You're being arrested for Gabby's disappearance, because there was no indication at that point that Gabby was dead. They were still looking for her as a missing person. Now, they did seize the van, and they may have had a warrant. I'm assuming they had a warrant for it, and they would have gone and said, we believe that there may be evidence of the crime, and these things add up. It's sort of a cumulative list. So you go to the judge and you say, Judge, so this woman is missing. There's a history of domestic violence. Her family are absolutely convinced that this is out of character for her, that she would never have left her van, that she would never have been out of contact with them. And yet Brian Laundrie comes home without her and in the van. We want to seize the van and search it to see if there's an evidence of a crime in the van. That makes perfect sense. But I think you definitely have to have a little higher level of probable cause if you're arresting someone. You really have to be able to say, I believe that Brian Laundrie committed this crime. At this point, you don't really have that. You don't have a body. You don't have any evidence of foul play. All you have is she's missing. And as we saw in a couple of cases not too long ago with a woman who disappeared from LA and turned up in Mexico, and the LA police were saying, look, I mean, she is a grown adult and she can go where she wants, and she does not have an obligation not to disappear. So it is definitely more complicated when you're talking about arresting a person and depriving them of their liberty. What else you got for me? Deb, this makes better sense. I had asked before why cases can take so long to get into court. Well, that's the reason, because we have a right to due process. And we want if we want our right to due process protected, we have to protect everybody's. So we have to assure that when police arrest somebody, that there's probable cause. We have to assure that when police go in and search someone's house, that there's probable cause, and that they have crossed the T's and dotted the I's, so that if and when evidence of a crime is discovered, that it can be admissible in court because it was legally seized. So, but sometimes it does take a long time. Now, we saw in the Vallow case, it took an inordinately a long time because things were shut down for COVID for so long. So Chad and Lori were arrested when they came back from Hawaii. Not Chad, Lori was arrested, and that was in late February, early March of 2020. But it wasn't until May of 2021 that she was indicted for the murders because they couldn't convene a grand jury. So what happened was they got the warrant to search the yard. They found the remains in the yard. They arrested Chad. But if you remember, the initial charges were tampering with evidence and some other lower level felony charges because they wanted to get them into custody. So because Lori, they had dropped they ended up dropping one of the charges, the most serious one, of abandoning her children, because they weren't abandoned, they were dead. And they wanted to keep her in jail, and they were having a hard time justifying $1 million bail for misdemeanors. So when they arrested them, then they were able to hold them on those felony counts, but it wasn't murder. And it wasn't until Chad Daybell had a preliminary hearing. I want to say that happened in early 2021, like February of 2021. But it wasn't, they decided they didn't want to have another prelim for Lori. And so when they indicted her on the murder charges, they did it with a grand jury. But because of COVID, they couldn't convene a grand jury until May of 2021. So you can see, I mean, things do get held up. Typically, if a case is presented to a grand jury and a grand jury returns an indictment, then the prosecution has a limited amount of time to actually serve the indictment, arrest the person, notify them of the charges. So these are all good questions, and I'm glad we've had a chance to really talk about the ins and outs of how a case gets started. Hi, Stacy. Are you following the Vincent Bataloro case? I am not. I'm curious how they decide to charge as a minor or an adult. He was 17 at the time of the crime. I'm going to look that up and we will talk about it next time. Um, Vincent Bataloro. I will look that up and we'll talk about it next time because I'm not familiar with that case. Um, uh, I have to look it up. It sounds like it's familiar and like it might be a case I'm thinking of, but I don't want to jump to it until I'm sure. So I'll look it up and we can talk about it next time. What other questions do y'all have for me? Hi, True Crime Sushi. You are welcome to monopolize. Uh, could they have detained him or any other person in other cases for questioning? For example, when did you last hear from, communicate, or see Gabby? Yes, they could have. But remember, we've all seen those police interrogations where the police have to sit there and say, "You're free to leave. You don't have to talk to us." And it's my understanding that Brian Laundrie just clammed up and said, "I don't have anything to say to you. I've told you everything I'm going to tell you." Gabby left. Period. So I don't know that there was um, at that point there wasn't a basis to arrest him. So the only thing they could have done was taken him down to the station and questioned him. But all he had to do is say, I'm not going to talk to you without an attorney, and they're done. Um, and it, he knew from the very beginning that he wasn't going to talk to the police. So. And unfortunately, his parents were protecting him, and it's very sad. Um, but you never know how you're going to react in that situation when it's your kid. Um, do you believe that your own child is capable of doing something so awful? Um, do you believe do you feel an obligation to try and protect your child? I mean, some parents do. Um, and I think that's where the Laundries were coming from. I think it was ill advised, and I think it was a very selfish position to take, but it wasn't necessarily a crime. They didn't obstruct justice. Um, I think the Petitos think they did, but under the legal definition, I think the court felt that the prosecution felt that there was not an obstruction case. So I have another question. Years ago, the FBI came to my house looking for a family member. I was in the hospital. My daughter was home alone. They came in with no search warrant. How is that legal? It's not. Now, the question is, and your daughter was 12, that's no good. But the question is, did they have an arrest warrant for your family member? If they had an arrest warrant, they could come into the house looking for that person. They could not open cupboards, open drawers, open anywhere a person couldn't be because they're not there to search or seize property. They're only there looking for the person. But if I don't know whether they actually had an arrest warrant or not. If they had an arrest warrant and they had probable cause to believe that that person was in your home, yes, they could come into the home looking for that person. They would have had to leave immediately once they determined that person wasn't there. So I don't know, but I'm assuming if they came in, they had a warrant. But if there was no warrant at the time, then no, they should not have come into your house. But the problem is you have a 12-year-old child there, and they say, "We're with the police," and, that's a scary, very scary thing for a child to have to deal with. So, but I'm sorry that happened, and I'm sorry you were in the hospital. So, what else you got for me, guys? Thank you for clearing that up. That was my understanding as well. He'd also retained a lawyer. However, it's common argument in true crime discussion. Okay, so yeah, I mean, I think from day one, Brian Laundrie said, the only thing I'm going to say is that Gabby walked away in this particular place, and that's all I'm going to say. She left, and I came home. Um, so I think, and particularly since he'd retained an attorney, the police had to understand they weren't free to question him. Yeah. Hi, Gail Swift Fernandez. How are you? Canton, Massachusetts has held Karen Reed's cell phones for over 500 days. Why have they not returned to her? This is an excellent question, and the answer is, hell if I know. So what's really interesting, and Melanie Little, of course, has been keeping up with this. What's really interesting is that the phones were seized, and her case is over. They should have been returned to her. So she asked for the phones to be returned along with her car. And the prosecution said, well, we're not sure because they might be relevant to an investigation involving Aiden Carney and whether she and Aiden Carney influenced witnesses or intimidated witnesses. Now, a grand jury refused to indict either one of them on jury tampering charges, but now the prosecution is saying, well, we still want to continue to investigate that. And I think that that is going to have to be something a judge decides. First of all, Karen Reed's phones are being held in her case. They were not seized in Aiden Carney's case. So the case they were seized under has been resolved and is done. And I think the argument is going to be these you have to explain to me how these are relevant to Aiden Carney, and you need to get a new warrant because the warrant that seized her phones had to do with John O'Keefe. Didn't have anything to do with whether or not the state was going to bring a charge of witness tampering. So it seems to me procedurally and legally that they, at a minimum, the state should have to go back and get a warrant for her phones. Now, do they have to turn her phones back to her and then get a warrant? I think there's an argument they could hold them until they had a warrant in the Carney case to seize the phones and extract them. But they need to be able to show a judge probable cause that evidence of witness tampering is going to be on those phones. Because right now, there's no probable cause to believe that those phones, there may have been probable cause to believe that there was information on them involving John O'Keefe and his death, but nothing in those, the reason for their seizure indicated that there was probable cause to show witness tampering. So I know that the weird part about it is Aiden Carney's attorneys don't really have any standing to go in and argue for Karen Reed's phones because they're not his. So Karen Reed's attorneys are having to go into court in Aiden Carney's case and argue that her phones, that they don't have the right to extract her phones in Aiden's case. It's crazy. And, Massachusetts just keeps getting worse. So that's a good question. So Let's see, anybody else have questions? I definitely will look up this Vincent Battaloro case. Probably butchering that. And we can talk about that. Any more questions before we close out for the night? I'm still fighting hoarseness. I don't know why. The allergist says it's not allergies, so I'm still working through it. So I appreciate you all bearing with me. Um, the next step will probably be ear, nose, and throat doctor. So we'll see. Um, but I appreciate you all being here tonight. Nice turnout, and I look forward to seeing some of you all on the replays. And so thank you for joining us tonight. Thank you, as always, Jen, for being the world's best moderator. And I want to say, I I went over the chat from last time and a few of the comments from the YouTube comments, and I was so gratified to see the number of people who talked about what a great community we have on this channel, and what how much people enjoy being able to interact on this channel in a way that is respectful and considerate. And so I just want to thank you all for that, because it wouldn't be um, it wouldn't be the community without you all. So thank you. I am going to say goodnight. Once again, anybody who knows anybody who's had a cochlear implant who'd like to visit, please let me know. My husband is going to have a cochlear implant next month, and he's anxious to talk to people who've been through the experience. So I'm sort of putting the call out there. Thank you to everyone who is here tonight. Don Shackelford, have an easy surgery on Friday and an easy recovery. And I hope that we'll see you, if not next week, the week after, to let us know how it's going. Everybody else, have a safe, lovely October, last midweek October, and I will see you next time. Good night.